Good morning. Thank you so much for joining us today for our Wednesday webinar, Social Security Disability for Vision Loss. Before we go any further, I want to give my usual disclaimer that today's webinar is not meant to be legal advice, but is instead just meant to serve as additional resource and information for those who are considering applying for Social Security disability benefits as a result of vision loss. I also want to mention that I do not answer any questions on the live webinar, and the reason for that is not because I don't want to help, but it's because we often need additional information, such as some of the personal identifying information or health-related information in order to be able to give a solid answer. And so for that reason, we do not take any questions on the live webinar, and same with on the replay, we cannot respond to pointed questions. Often we don't even approve pointed questions with a lot of information about health information or your own information included in the comments below the video. I do ask that if you have questions, we'll go ahead and drop in the live video now a link, and this link will be down below on the recorded video. If you do have questions, please do schedule a call with us. Please do reach out. You can schedule a call using the link. We just dropped it in the chat. The link is down below on the recorded video. And feel free at the end of the webinar, we will also provide our contact information. Always feel free to give us a call, send us an email. We truly do want to help, but we want to do so in a private setting where you can feel free to share information and share information back and forth so that we can help as best we can. So with that being said, let's get started. Here's our roadmap for today. We're going to first talk about some Social Security disability basics. Then we will get into some listings, what to consider if you don't meet a listing. And then finally, we close all of our webinars with a short list of some of the things that an attorney can help with in a Social Security disability claim. As I will likely mention again at the end, it is not an exhaustive list, but it's some of the things that we talk about most often with clients and potential clients. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, helping clients with their SSDI and SSI matters from the initial application through to the appeals council, which also includes the reconsideration and hearing stage appeals. Here's a little bit of background on Social Security disability cases. There are two different Social Security disability programs. They're both going to require that an individual be disabled and unable to work for a period of at least 12 months. Okay, where they're going to differ is with SSDI, Social Security Disability Insurance Benefits. That's what you've paid into the system while you were able to work. So that program has a requirement that you have to have a sufficient number of work credits. We typically will say that you must have worked 5 of the last 10 years in order to qualify for SSDI, and that monthly benefit amount is going to vary depending on what you were able to pay into the system while you were working. For SSI, or Supplemental Security Income Benefits, on the other hand, it doesn't have a work history requirement, but it does require that you have below certain income and assets. So income varies depending on household size. Assets is across the board. You cannot have more than $2,000 in assets if you are single, and more than $3,000 in assets if you are married. That does not include one home that you live in and one car that you drive, but it does include most things beyond that, including any bank accounts, investment accounts, retirement accounts, things like that. I also want to mention while we're on this slide that it does require that you be disabled for at least 12 months. That does not mean that you have to wait 12 months before you can apply. And in fact, we often encourage applications being submitted as soon as you know that you're going to be disabled and unable to work for that year. Okay. If it's not sure, if your doctors aren't sure how long you're going to be out, it's okay to wait and hold off on the application because sometimes Social Security will hold off on that. I've had situations where, they want to see, for example, in a cancer case, they want to see, does the chemotherapy or radiation help? Or is this something that is going to require significant treatment or have significant limitations for at least 12 months or more? When you submit your initial application for Social Security disability benefits, the agency will first look at that other prong Okay, no matter which program you apply under SSDI, they're first going to make sure that you would qualify. They're going to make sure that you have worked enough and that you have sufficient work credits. With SSI, they're first going to make sure that you are below their income and asset restriction thresholds. As long as you meet the secondary prongs for each program, or whichever program you applied for, you don't have to match them for both. You just have to meet whichever one you applied for. They will then start the 5-step evaluation process of your medical file. They're first going to look to see, are you currently engaging in substantial gainful activity? In 2023, that means, are you working 20 hours a week or more, or are you earning more than $1,470 a month? If you're doing either one of those, you will automatically be denied because you are engaging in substantial gainful activity and cannot be found disabled according to their rules. As long as you are not engaging in substantial gainful activity, the case will move to step 2, where they will look to see, based on the medical records, do you have at least one severe medically determinable impairment? If you don't, the analysis stops there. They'll deny the claim. They'll say you don't have any severe impairments, so by our definition, you cannot be found disabled. If you have at least one severe medically determinable impairment, then it will move to step 3, where they will see, do you meet or equal a listing? We'll talk about 3 of the vision loss listings in just a moment. If you do meet or equal one of those listings, the analysis stops there. You'll get an approval saying that you meet listing blah, blah, blah. And that's the first decision. Then you'll get a notice of award that will explain what your actual monthly benefit will be. If you do not meet or equal a listing, they'll go to step 4, where they will create a residual functional capacity for you based on the medical records. That RFC is essentially what the Social Security Administration thinks you can perform in light of the limitations that you have as a result of your conditions. So they'll create that RFC and they'll say, okay, can an individual with this RFC go back and do this past relevant work? If you can, your claim will be denied. Social Security will say, we believe you can go back to your past relevant work. If, based on your RFC, you cannot go back to your past relevant work, the agency is going to look to see, is there any other job in the national economy that you can do with that RFC? Okay. We did other webinars previously on the grid rules. If you're between the ages of 50, 55, 55 and 60, or 60 and 65, that might be something to look into. The grid rules do come into play there when they're considering whether you're able to engage in other work. Individuals under 50, the agency is going to look at not just what you have been trained to do, but any job that might exist in the national economy. Okay, so that's an important thing to note. If you've been trained as a nurse, as a teacher, as a lawyer, that's not what they're looking at. If you're under age 50, if there's any job that you can do, then that could possibly result in a denial. So for vision loss, Social Security will need to see vision testing to understand the severity. They're going to generally look for visual acuity testing for distance that is carried out using the Snellen methodology or another type of methodology that's comparable to Snellen methodology. They will not use results from pinhole testing or automated refraction acuity to determine your best corrected central visual acuity. They do note that your best corrected central visual acuity for distance is typically measured by determining what you can see from 20 feet away. If your visual acuity is measured by any distance other than 20 feet, they convert it to that 20-foot measurement. For example, if your visual acuity is measured at 10 feet and is reported as 1040, they will convert that to 2080. So here you will see 2.02 loss of central visual acuity. They're going to look at the better eye. They're always, always, always looking at the better eye. So if you have one eye that after best correction is 20/200 or less, but the other eye is better, you still won't meet this listing, okay? So it does require loss of vision in both eyes, and they're always going to look to what is the measurement of the better eye, okay? So here we've got contraction of the visual field, again, in the better eye. So here are 3 ways that you can meet listing 2.03 in the better eye. So again, they're going to look at both eyes, but they're always going to take the measurements from the better eye to determine whether or not you meet one of these listings. And then finally, 2.04 is loss of visual efficiency or visual impairment. Finally, again, in the better eye, okay? So as you can see, again, this is only looking at the better eye. You can have one eye that is not as good as this, but if the other eye is as good or better, then you're going to have an issue with meeting the listings. So it does need to be both eyes that have the limitation, and the better eye of the two has to be the one that meets the strictness of the listing. So as you can see from looking at these three listings, Social Security for disability for vision loss can be really difficult, especially if it's just the one eye. It's instead going to kind of turn on having a condition that results in the RFC such that you cannot perform your past work or any other work. So if you've got a total vision loss in one eye and the other eye is weak, but not as bad as the listing needs, then you will need to explain and have your doctors explain what impact that has on your day-to-day functioning. So if you don't meet a listing, you can still qualify for SSDI or SSI benefits if you have an impairment that matches a different listing, or if the loss of vision is the only impairment that you have. And I don't say that as if it's, not a big deal, because it is, but if that's, the main thing that's preventing you from working, it very much can be. And so in that case, what it comes down to is, what is your residual functional capacity? Do you have limitations with what you can do as far as postural limitations? Climbing, stooping, kneeling, crouching, crawling. Do you have difficulty seeing out of your peripheral vision? Are you unable to drive, handle, hazardous machinery, anything like that? What needs to be knocked out so that you can eliminate not just your past work, but remember, all work? Okay. Here's a short list of how an attorney can help you. Here's some of the things that we can do. We can provide guidance on what correspondence from Social Security actually means, as well as file necessary appeals if we are already representing you, or you get to us in enough time after the initial or reconsideration or hearing denials. We do review your medical records in your case file. We can discuss what additional records may be helpful in your case. We can review your documents for accuracy and completeness. When Social Security will send you forms to fill out, we will almost always ask that you fill them out because it is essentially testimony without having to go before a judge. It's often a way for you to explain to Social Security what you experience on a day-to-day basis. As much as we can empathize and listen and understand what you go through, we are not in your house. So we don't know perhaps what limitations and accommodations you have to make for yourself with different activities of daily living. So we do ask that you fill those forms out, but we're happy to review them, happy to talk about them with you before they get sent in. We also will work with you to provide relevant updates to and from Social Security throughout your claim. If you get to the hearing stage, we do prepare you and any witnesses for that hearing. Oftentimes, we do something a little bit different with our witness testimony, whether that's a spouse, close friend, prior employer, or prior coworker. We do have a way to get that testimony in typically. The additional witnesses that are often present do include the medical witness or the vocational witness, which are often asked to be present directly by the Social Security Administration. So again, this is not a complete list. It is just a sample of some of the things that we can do to help you throughout your claim. Also, as promised, here's our contact information. We'll go ahead and drop the scheduling a call link again in the chat on the live. That link is down below. Feel free to also give us a call, send us an email. We truly are always happy to help in any way that we can. Thank you so much for joining us today and watching. Have a wonderful day.